We're going to learn a lot about elder law as well as our rights for seniors.
A certified elder law attorney is an attorney who has earned an advanced certification from the National Elder Law Foundation. There's actually only 10 CELAs in Illinois right now.
What are the legal danger zone or specific risk families face when they wait until a medical crisis occurs to establish a power of attorney?
Often they've waited too long and the person is no longer able cognitively to understand the documents and execute them. We end up in guardianship court, and that's really costly. It's public. It can be very upsetting for family dynamics. If you can set up your own wishes beforehand, it is far better.
Most people think that planning for the future is just about writing a will. But when a health crisis like a stroke or dementia diagnosis hits, the business of aging becomes much more complicated. You have to worry about who makes the medical decisions, how to protect your home, and how to pay for the care you need. Today, we're joined by Heather Voorn, a board certified elder law attorney. We're going to bridge the gap between the legal paperwork and the actual hands on care so you can stop worrying about the what ifs and focus on your loved one's recovery. Welcome, attorney Heather Voorn. And Heather is a certified elder law attorney. And we're going to learn a lot about elder law as well as our rights for seniors. So it's good to see you. Happy New Year, Heather.
Happy New Year. Thanks for having me.
Thank you for being on. This is exciting because there's so much knowledge in that head of yours that that we can share with our seniors. And being in the home care for such a long time in that space, there's a lot that we see as home care providers that we can only do so much, in terms of passing along information to those individuals who are in need. But now that you're on, you can give the real deal and let folks know what is and what isn't when it comes to, elder law. So tell me, what exactly is a certified elder law attorney?
A certified elder law attorney is an attorney who has earned an advanced certification from the National Elder Law Foundation. We
Uh-huh.
refer to it as NELF. There's a lot of alphabet soup in the law, so I'll
Okay.
probably be using some acronyms, but the National Elder Law Foundation certifies CELAs, which are the Certified Elder Law Attorney. It is accredited by the American Bar Association as well.
Uh-huh.
And really, CELAs are attorneys who have practiced for at least 5 years in a substantial amount of elder law matters. We have to show that we've dedicated so much time to certain types of matters and our practice to elder law. We also have to take a rigorous 1 day exam testing on all these elder law topics so that we can prove that we actually do have the breadth of knowledge to back up the certification. We also require peer references.
Okay.
And I will say in Illinois, it's interesting because Illinois doesn't require any specialties for
Hmm.
practicing law. So there's actually only 10 CELAs in Illinois right now.
Really?
Really. And while we don't really market that it's a specialty because that's not really allowed for under Illinois law, it does show we have a true dedication and passion to the field, and we really wanted to take our career to the next level and become certified. So
Okay, that's great. So first of all, why did you become an attorney? And then second, why did you decide that elder law was the thing that you wanted to do?
that's a great question. I actually knew I wanted to be an attorney pretty early on, but I thought that I wanted to go into criminal law. My
Hmm.
major in undergrad was criminology.
Okay.
And while I was working through college, I worked for a management company that managed the Florida elder law attorneys group down there. So we got to know the attorneys that were doing this work. We helped put on their conferences. So
Hmm.
I got to see what they were doing and really the help that they were providing families and seniors. So I kind of switched course and went towards elder law because of it.
Okay, awesome. And then why is this specific credential vital for families dealing with chronic diagnosis?
So Elder law, I feel, is more of a holistic approach to practicing law. We kind of, as elder law attorneys, we kind of fit a complex intersection between healthcare law, estate planning, benefit law.
Yeah.
So there's a lot of changing and moving pieces in those areas. The law is constantly changing, benefits are constantly changing.
Hmm.
So I feel like it's important to really focus. If you're going to do this, you really need to focus on that area because you won't be able to keep up with all the changes if you're
Yeah.
just.
Yeah. Okay. Well, in terms of elder law or seniors, if you want to couple those two together, because when I say elder law, I just think completely seniors on the board, right? So what are the legal danger zone or specific risk families face when they wait until a medical crisis occurs to establish a power of attorney? First, explain to our audience what a power of attorney is.
Sure. I'd also like to just add that, elder law obviously has the word elder in it, but it also encompasses just adults with disabilities,
Mm.
minors that have disabilities,
Mhm.
needs planning. So
Okay.
really anybody that's, you know, older or has some disabilities, we kind of handle all of that. So
Okay.
it's just grouped under elder law.
Good FYI. Yes. Thank you.
So
So, mhm.
you asked about powers of attorney,
Mhm.
and I think they're probably one of the most important documents people can have. Once somebody turns 18, I
Mhm.
suggest that they get powers of attorney. We have two kinds in Illinois, one for healthcare and one for finances or property. And
Mhm.
it's basically a document where someone can say, if I'm not able to make medical or financial decisions, I appoint my agent to make those decisions for me, and you can specify your wishes in those documents.
Mhm. Okay. So then what is the danger zone for a specific risk families face when they wait for medical crisis to establish a power of attorney?
So I would say generally nobody wants to think about the possibility that they're not going to be able to handle their affairs or they're going to decline or
Mhm.
if it's in relation to their parents, a lot of children don't want to believe their parents are vulnerable or that
Yeah.
these things are going to happen to them in the future. So, you know, it's important to pre-plan. I have a lot of clients who say like, I don't want to think about that, Heather. It's morbid. And if I put it out there in the universe, it's going to happen or it's going to inflict some sort of bad luck on them.
Mhm.
And I get it, but it's so much worse if you don't do that planning.
Right.
To your point, some of the danger zones is really that if they wait till a medical crisis arises to do planning, such as powers of attorney, often they've waited too long and the person is no longer able cognitively to understand the documents and
Mhm.
execute them. And if that's the case, then our options are far more limited on what we can do to help protect them or, support their wishes. So that's probably the biggest danger zone is if you wait too long, we might not be able to do anything. And if that's the case, usually what we end up, if we can't do powers of attorney and they didn't exist prior to incapacity, we end up in guardianship court, which we can touch on a little bit later too. But
Yeah.
that is where someone has to go through the court process to be appointed as a guardian of the estate or guardian of the person to be able to make those decisions with some sort of authority vested by the court. And that's really costly. It's public. It can be very upsetting for family dynamics.
Mhm.
It's certainly the last resort and it's necessary sometimes, but if you can set up your own wishes beforehand, it is far better.
Yes. And I'm glad that you touched on that point about guardianship because what we see in home care is that last minute, that when they're in that danger zone, when they call and say, hey, mom has dementia or dad has dementia, And then, we have to then kind of backtrack as a home care company because we need powers of attorneys in order for someone to say, my loved one needs care, because we need to know that you are the decision maker in this. And you mentioned that it is costly. So what ends up happening in a lot of cases is that they don't pursue the guardianship. Then there's family infighting in regards to who's going to care and where the money's going to come from, or who's going to take over the bank account and who's going to make decisions. And like you said, in Illinois, it is the healthcare power of attorney and then financial. So I want to take a step back a little bit, because when there's hospitalization and there's no legal powers of attorneys in place, then the hospital have their own documentation for powers of attorney. And what families don't understand is that does not go outside of the hospital. It is just so that hospital can help you make decisions on what's next or what treatment will be for your family. So could you touch on that a little bit, please, Heather?
Sure. Sometimes those documents can actually go outside of the hospital. So
Okay.
it can get a little concerning. Let's say I have a client who took the time to do pre planning and got everything set up and has the healthcare power of attorney. Maybe there's a medical crisis where they go into the hospital and either they get there and they don't, someone doesn't know they already have the power of attorney or they don't remember
Hmm.
and the hospital has them sign a new one. It can revoke the old power of attorney. So you have to be really careful about that. And so sometimes those documents done on a crisis moment in a hospital
Hmm.
can really disrupt their formal estate plan that they thought so thoughtfully about.
Wow. Okay. That I did not know. So when someone goes into the hospital and there's no powers of attorneys in place, then the hospital have you sign that power of attorney. You mentioned it can extend outside of the hospital. So is
Yes.
there an extended amount of period where that is available for use, for lack of a better word, or is just from now till now on?
It really just depends on the terms, and because
Okay.
you can set it up where, hey, this is in place from said time to said time.
Mhm.
So you could, if you had the ability, you can say, hey, I want this in place from today until I'm discharged from the hospital. But if the language in the hospital healthcare power of attorney says it revokes any prior ones, your old one would be revoked and this new one would be in place. So it's very much governed by the actual terms of the document.
If today's conversation is making you realize that you need more support at home, the Right Choice Home Care is here to help. While an attorney like Heather protects your legal rights, we protect your daily quality of life. Our caregivers are trained to follow the plan your medical and legal team have put in place, ensuring safety and medication consistency. Let us handle the daily routine so you can have a peace of mind. Visit us at rightchoicehomecare.com to learn how we can support your family's journey. Now, back to our interview. Okay, so let's just say someone is incapacitated and their loved one comes in and the hospital makes them sign, or the hospital present to them that power of attorney. What is supposed to happen during that period? Because that person is incapacitated. We don't know whether or not they have a power of attorney in place. So that individual cannot say, I want it from this time to this time.
If somebody's incapacitated to that level, they really should not be signing a new power of attorney. And so, because they wouldn't presumably have the capacity to do so.
Mhm.
And so, under that circumstance, there is something called the Healthcare Surrogate Act in
Mhm.
Illinois, which has a hierarchy of who can make medical decisions for someone if they can't do it themselves.
Okay.
Uh, and so the hospital might follow that, and there's different provisions as to when people can make decisions, what kind of decisions based on the statute. And this is where it gets a little dicey because if there's family members who disagree on care, the hospital might push people to get guardianship. So somebody has legal authority to make those decisions, and the hospital can take direction from that person appointed by the court.
Yes. So at what point, and you touched on this briefly, so at what point in a diagnosis like dementia? Is it legally too late for a loved one to sign documents? And what if there's no power of attorney in place? So I'm sure you see this a lot.
I was gonna say we get this a lot. Sometimes families come in and mom is like, I'm supposed to ask you about this, Heather, and I don't really know why I'm here, or things like that. And we find out that maybe there's been some diagnoses, there's some cognitive impairment. Um, and so I once heard capacity described as it's not a light switch, it's a dimmer. So it's kind of like a continuum. There's different levels. If you have a diagnosis of dementia, it doesn't necessarily mean you can't do some of the planning.
Hmm.
It really depends on where on that continuum you are with your capabilities.
Okay.
So, as a typical lawyer answer, which everybody just loves, I usually say it depends, but truly, capacity isn't black and white
Hmm.
when you have a diagnosis of dementia. It's more of a gradual progression. And on top of that, there's different capacity levels for different documents. So,
Okay.
somebody might be able to do a healthcare power of attorney who has maybe moderate to more advanced dementia, but maybe they can't sign a property power of attorney. They can only do the healthcare one. And maybe they can't do a will or trust at that point. But someone early on in a diagnosis setting where they've just started realizing there's a little bit of forgetfulness, but they still have most of their faculties,
Hmm.
they may be able to execute the full estate plan.
Mm. Okay. So that brings me to this question. When you have a senior or someone, an adult, let's just go with an adult, that is afraid to put a power of attorney in place because they feel as if their rights are being taken away or they no longer can make those decisions for themselves. Could you talk a little bit about that, please, Heather?
Absolutely. It's another great question. One of the beauties of engaging in estate planning and getting your advanced directive, like powers of attorney, in place is you get to control what you want it to say. And you get to say, I want it to take effect after my doctor says I'm not competent, right? So you're in control until a certain point, and when a doctor or medical provider might suggest, hey, daughter, your mom's really not able to comprehend this. I think you need to start acting. Sometimes I've found in my practice that it's hard to get doctors to take that position against some of their patients. Maybe
Mm,
they're longtime patients and they don't want to say, I don't think you're not able to handle this, right? Or they're worried they might lose that patient sometimes.
yeah. Yeah.
So a lot of times we're doing powers of attorney where they're effective immediately so that we don't have an issue that, hey, if they lose capacity in the future and we can't get a doctor to certify that, there's no one able to act.
Yeah.
So there's different ways you can set it up. And it's something that I talk with all my clients about is what's your preference? Here's the pros and cons of both, but I always want to focus that they're in control. These are amendable documents generally, at least the powers
Yeah.
of attorney, so they can always change it too.
Yeah. And if you find where, have you found where you've had families who've been in disagreement and want to amend the powers of attorney?
So certainly we've seen that. Sometimes those end up in guardianship if we have competing powers of attorney and there's issues with capacity. But the person who gets to make the decision on whether those are changed is the principal, or in your hypothetical, the adult who's coming to me. So they're the only ones that get to say, Heather, I want to change it. We can talk about why they want to change it, what are the pros and cons of their wishes, and why they're doing it. So, we can advise them, is it a good idea? What's going on right now? That type.
Yeah. So if have you we're still in our relationship building process of us, really building a relationship beyond what we currently have. So I'm going to ask you this question. How does an elder law attorney coordinate, or have you found where you've had to coordinate with home care agencies to ensure that the client's daily care aligns with their legal and medical directives?
Absolutely. it, as I said, it's kind of a holistic practice. So we do work with, it's kind of a team. We've got
Hmm.
healthcare providers, medical providers, the fiduciaries, the powers of attorney, trustees, things like that. So it takes a whole team really. And so from a standpoint of working with home care agencies, a lot of times, just like you alluded to earlier, we're talking about ensuring that those POA documents are in place so that the caregivers know who can authorize services, whether it's medical or paying the home care bills. So they know who to take direction from. Because sometimes other family members try to be helpful and insert themselves, but we want to make sure it's clear who's actually got the authority here.
Yes.
Sometimes we help in negotiating the contracts or also drafting care agreements for some family members that are caregivers that might work with a company as well. There are specific rules when there's family caregivers involved.
Yeah.
We also want to make sure that payments set up properly from a tax standpoint because there can be some tax consequences. So we often work with the agencies on that. Sometimes HIPAA releases, things like that from a legal standpoint. We're often a sounding board too if caregivers notice there's something kind of amiss. I've had caregivers reach out directly to me or a client of mine who might have had some mild cognitive impairment, and the caregiver's like, I think you should know about XYZ, Heather.
So, which brings me to this question, because we've had this happen with us in home care where the parent clearly knows who they want the power of attorney to be for whether it's health or finances. Then the families are at odds with each other because you have one person who feel like they should be making the decision on behalf of their parent. And so the other families, because they don't want to find themselves in any type of argument or confrontation with that other family member, that power of attorney will then step back and let that other child, adult child, take over all of the decision making when it comes to the family. And I've seen that. And I am only saying that because I've seen that happen. Have you experienced that at all?
I have seen some situations where the family dynamics can get a little dicey in those. And if, you know, generally, I'm either representing the elder who did the POAs, so that's my client, or sometimes I'm hired by the power of attorney to represent them in carrying out their duties. And so what I would say is, if I was representing the elder, I would be talking to them about who do you really want? Like it is
Hmm.
your choice, and we can clarify that. And but if elder wants daughter and daughter doesn't want to do it, then we need to figure out who would be the next best option, right? So
Hmm.
sometimes it does take a little bit of, you know, discuss discussion with family and really figuring out what's going on. But ultimately, in that scenario, I only really care what my client wants, and I can talk to my client about, well, I know you want your daughter, but your daughter doesn't really have the ability to do it. So who could be the next best option for you to kind of get that all straight? But if I've been hired to represent the power of attorney and helping them, I would be telling them, you have a duty. You can't just let somebody else make these decisions because if something goes sideways, you could be on the hook.
Yeah.
So they really need to either step in officially and handle it or resign and let somebody else step in.
Okay. And in that instance, and where they resign mentally, they resign mentally and just say, okay, you, because you want to make all the decisions, you go ahead and make all the decisions again to avoid confrontation. Is that legal?
I would, again, I think there would be exposure there if it's just a mental resignation because they are still formally the agent. So in those scenarios, if the client was the power of attorney agent, I would be saying, if you don't want to do this because you want to avoid conflict, you need to formally resign. And we prepare a resignation, we have them sign off, and they step down. And then the successor agent would step in.
That's interesting. I did not know that you can actually resign from being a power of attorney. Hey,
You
folks,
can.
get it together. Step up. And, when we've given talks as a home care provider about powers of attorney. It's letting the family member or the adult know, or the adult child know, or the senior know that just because you have your oldest child and does not mean that that oldest child want to be the power of attorney, right?
Or should be.
Or should be. It's, and I tell this to my audience all the time is, your children. So because you know your children, you need to make that decision based on the fact that you know your children. If you know you have an adult child and all their lives they haven't made good decisions and all they've done is party, that may not be the right person that you want to put in place. Am I correct in saying that?
Absolutely. It's a conversation I actually have more often than I care to admit. I did have a client who was like, "Well, I have to name my son. He's the oldest." And then so I started asking about son. I'm like, "Tell me more about him." And then I find out that he's had several bankruptcies. He has a lot of issues with funds and finances. And I was like, "This is the last person. He might be very lovely, but this is the last person that really should be handling your finances.
Mhm.
Maybe put him in as healthcare power of attorney, but for the financial side, I don't think that that's the best choice for you."
Thank you for clarifying that.